Hi, welcome to Oliva Gibbs Energy Education Series. Today we'll be presenting on produced water law in Texas and New Mexico, diving into state legislation, comparing the Produced Water Acts, and looking ahead for what's next for Texas and New Mexico. My name is Baylee Pearce, and I'm an attorney out of the Houston office.
And I'm Jason Smith, and I'm an attorney out of the San Antonio office.
Our information is here on the slides. If you have any questions related to what we're talking about, or just want to chat, please reach out. We will start with what is produced water. The states have different definitions, but generally it is fluid waste from oil and gas operations. We see it in hydraulic fracturing or fracking. Essentially, fracking fluid is injected in, and this fluid, along with gas and other minerals, comes back up. The next figure is what happens after the produced water comes out of the ground and is separated from the hydrocarbons. Typically, it is put into tanks for 24 to 48 hours, then transported away to either be treated or, more commonly, injected into injection wells. If it isn't put into tanks, it can be put into an impoundment, which is an open air structure designed to facilitate evaporation. So essentially, water evaporates off and the solids settle to the bottom, and then these solids are removed. If produced water is taken to a treatment facility, it is then used for things like surface water discharge, irrigation, road de-icing, or dust suppression. We will briefly discuss the uses later, but for a more in-depth discussion, please refer to our Murky Waters presentation that Isabel Huntsman and I did back in September. You can see it on YouTube. This figure is to kind of give you an idea of the volume of produced water in oil and gas producing states. This figure is from 2021 from the Groundwater Protection Council. The numbers are kind of blurry, but know that the darker the blue, the more produced water. In 2021, Texas was the #1 producer of produced water, but 8 states reported more than 1 billion barrels of produced water in 2021, including New Mexico.
And now we'll discuss what's going on with produced water in Texas. The Texas Produced Water Act was introduced as House Bill 2767 in 2013 by Representative, now Senator, Phil King of Weatherford. It became effective on September 1, 2013, and it can be found in Texas Natural Resources Code, Chapter 122. Now, the Texas Produced Water Act defines produced water and establishes the rules regarding ownership and tort liability, and it also establishes which regulatory agencies are in charge of which aspects of produced water. It also directs the Texas Railroad Commission to regulate the treatment and beneficial use of produced water. Now, the definition of fluid oil and gas waste in the Texas Natural Resources Code specifically includes brine, hydraulic fracking fluid, and flowback water. It's also important to note that anything that applies to produced water that we discuss in this presentation also applies to those waste products and any other fluid waste as well. Now, ownership of the produced water is basically rule of capture with a twist. The produced water is the property of the person who takes possession of the water for the purpose of treating it for subsequent beneficial use. Upon transfer of the treated product, it's kind of like a relay race. When the produced water is handed off to another person for disposal or use, ownership passes to the transferee. Now, parties are permitted to designate ownership of produced water by express provision in any legally binding document. So if you want it to operate differently than the statute, you're really going to have to put it in writing. Now, when an owner delivers produced water to a treatment facility, they're shielded from liability for damages related to the subsequent treatment and use of the treated water and exposure to treatment byproducts. When a producer either puts produced water to beneficial use or transfers produced water to another under a contract for treatment and beneficial use, they're no longer liable for damages resulting from its subsequent use. Please note that both of the above provisions also apply to surface owners generally as well. Now, surface rights owners of lands where produced water is produced are not liable for any personal or property damage resulting from exposure to produced water, treated produced water, or any treatment byproduct. Now, these provisions do not affect producer or transferee's liability to the surface owner under common law, statutory law, regulatory law, or any other law. This carve-out also includes violation of a TCEQ discharge permit, violation of a handling hauling permit issued by the Railroad Commission, as well as violations of the next section of the Natural Resources Code, in which the Railroad Commission is in charge of establishing rules for siting standards of recycling pits, technical construction and placement standards for produced water, standards for estimating closure costs, minimum and maximum bonding requirements, and sampling and analysis standards. The Railroad Commission is also responsible for issuing permits for the commercial recycling of produced water. The Railroad Commission has 90 days to approve a permit application, but if no approval is given, the permit is deemed approved. In 2025, the Texas Supreme Court heard Cactus Water Services versus COG Operating, which is the first major case involving produced water in the state of Texas. The facts of the case are that COG acquired approximately 37,000 acres in Reeves County from leases taken between 2005 and 2014. Between 2019 and 2020, the surface owners of those leases executed agreements purporting to convey rights to produce water to Cactus Water Services. COG eventually sued Cactus on grounds that COG had the exclusive rights to produce water under the leases. Now, the Texas Supreme Court found that absent any express provision in the lease to the contrary, produced water resulting from operations under the lease is the property of the lessee. The lessee's rights under the lease include the right to use subsurface water as part of the surface estate, as is reasonably necessary for oil and gas production. Now, produced water is also subject to laws focused on oil and gas production and environmental safety concerns, which are in place to protect water quality. As a result, the court determined that water and produced water are not interchangeable. More specifically, as liquid oil and gas waste, lessees and operators are burdened with the duty of handling and disposing of produced water. Now, while this was a unanimous decision, Justice Busby's concurrence points out that this is a default rule only and that parties are free to make their own arrangements. He also pointed out that this decision is limited to produced water and other liquid waste only under the Produced Water Act. This does not affect prior decisions regarding production of unleased minerals or substances that may be produced as part of production. Also, this decision does not address whether lessees have an obligation to the surface owner in a situation where the minerals have previously been severed. This also does not address whether any royalties are owed to such surface owners as a result of the produced water. If royalties aren't involved, we still don't know how the parties would account for any profit or loss from use or disposal of the produced water. Finally, whether the lessee owes any implied covenants to the owner of the surface estate is still an open issue. In 2021, the Texas legislature created the Texas Produced Water Consortium. The Texas Produced Water Consortium is comprised of a wide group of stakeholders in the produced water space, including oil and gas producers, government agencies, environmental groups, engineers, and academia. The consortium was established to explore innovative ways to treat and reuse produced water. In 2023, the Texas legislature allocated $5 million to the consortium to advance its efforts. In 2024, the Texas Produced Water Consortium gave its most recent report to the Texas legislature. In it, they outlined the pilot projects they were using for utilization of produced water, which includes use and irrigation and discharge into surface water. They also outlined their work with the Railroad Commission and TCEQ on review of data and analysis on produced water treatment and qualities. They also gave a report on their research into economically viable use, including alternative crop irrigation, mineral recovery from produced water, and the potential for municipal use in the future.
All right, now to produced water in New Mexico. To give context, there are two major areas of oil and gas production in New Mexico. As we can see on the map from the Bureau of Land Management, the two major formations are the San Juan Basin and the Permian Basin. The Permian Basin in the upper corner has coal, gas, and some oil production, whereas the Permian Basin is primarily oil and gas production. It is important to point out the two formations because produced water from the two areas are going to be very different. One major thing about produced water in the Permian is how salty the water is. This makes it more difficult when we are talking about irrigation for non-food crops. For example, we have corn that can be made into things such as ethanol or biodegradable plastics. That crop does not like the high salinity in the Permian water. However, a crop like alfalfa or cotton has shown to have an affinity towards the high salinity in the Permian produced water. So it's important to contextualize New Mexico oil and gas production when talking about produced water and its future. Moving to New Mexico's Produced Water Act. It was introduced as House Bill 546 and went into effect July 1st of 2019. You can find this act codified in Chapter 70, Article 13 of the New Mexico Statutes Annotated. The act accomplishes several things, but important for this presentation is that the act defines produced water, provides authority to state agencies, and clarifies ownership of produced water. Under the act, produced water is defined as fluid that is an incidental byproduct from the drilling of oil and gas. Now onto the regulators. If you're unfamiliar with water law in New Mexico, it's important to note that under New Mexico law, all ground and surface waters belong to the public and are subject to appropriation under the doctrine of prior appropriation. So, to put this in context for those of us from Texas, if you want to drill a water well on your property in New Mexico, you would have to go to the state engineer and get a permit. This is important because one of the very first questions I asked when I was learning about Texas versus New Mexico produced water law is, could we see something similar to the cactus case, but in New Mexico? I was told by an attorney in New Mexico that this really wouldn't be something that would come up because of the water laws I just discussed. So on to the Produced Water Act in New Mexico. Under the Act, the Oil Conservation Division of the New Mexico Energy, Minerals, and Natural Resources Department regulates produced water with respect to the reuse of produced water for oil and gas uses. The New Mexico Water Quality Control Commission handles water for all other uses. So when we're talking about the reuse of treated produced water for things like irrigation or dust suppression, we're looking at what the Water Quality Control Commission says. Finally, you don't need a permit from the state engineer for the disposition of produced water, recycled water, or treated water. Now onto the ownership of produced water. The Act provides that unless provided by law, contract, bill of sale, or other legally binding contract, all produced water from an oil and gas well is the responsibility of and under the control of the working interest owners and the operator of that well. The working interest owner and the operator have the possessory interest of the produced water, which includes the right to take possession of the produced water and to use, handle, dispose of, transfer, sell, convey, transport, recycle, reuse, or treat the produced water and obtain proceeds for any such uses. While the working interest owner has the possessory interest and may do all those things, it's the duty of the operator to do all of those things. Once the produced water is transferred, sold, or conveyed, the transferee has the control and responsibility of the produced water until it's transferred again. So, thinking back to that graphic earlier where it was like the life cycle of produced water, every time there was that little arrow, that person who took possession of the produced water for a purpose then had control and responsibility of the produced water. It's also interesting to note that the Act prohibits private parties from charging for the transport of produced water across state lines or requiring fresh water to be purchased and used where recycled produced water is available. So now on to the New Mexico Produced Water Consortium. So similar to Texas, New Mexico has their own produced water consortium. The New Mexico Produced Water Consortium was created to fill the scientific and technical gaps needed to guide protective science-based regulations for the safe treatment and reuse of produced water. The consortium brings scientists, academic institutions, nonprofits, government agencies, and industry partners to advance research, accelerate technology, and build public and private partnerships that support the safe water management and sustainable economic growth in New Mexico. Also similar to Texas, the New Mexico Produced Water Consortium also sees over these pilot projects. They have what they call pre-rule pilot projects and then just regular produced water pilot projects. These pre-rule pilot projects basically are looking at the treatment of produced water to try to get it to what the Water Quality Commission considers to be safe for reuse. This is different from the produced water pilot projects like we have in Texas, where they use the treated produced water for things like irrigation. So you can see on the slide, 4 of the 12 pre-rule pilot projects have been completed, and there are no produced water pilot projects in the state of New Mexico. Moving on to federal lands. If you're familiar at all with New Mexico oil and gas, you know that there's a lot of federal land leasing. As you can see in the graphic, the yellow is the federal land, so producers are working with the BLM. The lime green outline in the bottom is the Permian, so you can see there's lots of yellow there. And then in the top corner is the San Juan Basin, and you can see all the yellow there. The BLM New Mexico office covers New Mexico, parts of Texas, Oklahoma, and Kansas, and is in charge of 45 million acres of mineral estate and 2 million acres of Native American mineral estate. I do just want to say, for purposes of this section and this webinar generally, we won't really be getting into any tribal or Indian law. Back to federal law. As of June 16, 2023, Title 43 of the Code of Federal Regulations pertaining to public land provides for the disposal of produced water from completed wells on federal and Indian oil and gas leases. This section states that all produced waste from federal and Indian leases must be disposed of by injection into the subsurface, discharge into pits, or other acceptable methods approved by an authorized officer. An authorized officer is any employee of the BLM that is authorized to perform duties under Parts 3000 and 3100 of the Code of Federal Regulations. While injection is generally the preferred method of disposal, the section outlines different procedures for the disposal on federal and Indian land, both on lease and off lease, and for state and privately owned lands. As of May 1st, this is the section the federal government still adheres to. So now that we've given you an overview of the law, we're going to compare the two states. Texas and New Mexico face similar issues, the first being the drought. As of April of this year, 2/3 of New Mexico is in the severe drought category. Texas, similarly, could face a 2.25 trillion gallon water shortage by 2070 if steps are not taken to mitigate. If you're interested in Texas's water issues, we go more in depth at our Murky Waters presentation that I mentioned earlier. Second, if you look at the figure of the Rio Grande watershed, you can see that the two states share a significant portion of our surface water resources. This has led to 2 big water disputes. In the 1940s, the two states adopted the Pecos River Compact, creating the Pecos River Compact Commission. This compact allocates the waters of the Pecos River between Texas and New Mexico. The origin of this compact is Texas's belief that New Mexico was taking more than their fair share of water from the river. So the compact states that New Mexico can't deplete by man's activities the flow of the Pecos River at the New Mexico-Texas state line below an amount which will give to Texas a quantity of the water equivalent to that available to Texas under the 1947 condition. This compact has understandably led to conflict between the two states. Interesting for our purposes, though, in the event of importation of water by man's activities to the Pecos River from any other water basin, the state making the importation shall have the exclusive use of the imported water. This is interesting because several companies are actively seeking permits from the Texas Commission on Environmental Quality to treat and discharge millions of gallons of produced water into the Pecos River watershed. The second compact, the Rio Grande Compact, has seen litigation over everyone using their fair share that has gone as high as the Supreme Court of the United States. Similar to the Pecos River Compact, the Rio Grande Compact was entered into to ensure Texas receives its equitable share of quality water from the Rio Grande and its tributaries in Colorado, New Mexico, and Texas above Fort Quitman. In 2013, Texas sued New Mexico based on claims that New Mexico was receiving more than its equitable share of the Rio Grande. This suit has made its way all the way up to the Supreme Court of the United States, and a settlement has been reached. However, the settlement hasn't been completely approved. It's been approved by the Supreme Court Special Master, but the justices have the final say, and they're the ones that can ultimately dismiss the case. On top of water issues, even though the increase is small, there is an increase in production in the Permian Basin, meaning more produced water that we need to find something to do with. Finally, with the rise of AI, we can see an increased demand for data centers. Texas is on track to become the largest data center market on Earth. And while not building as many data centers at the same rate, New Mexico currently has 22 data centers operated by 11 providers. We'll touch on this later, and Oliva Gibbs has several presentations over this topic, but treated produced water can be used in the cooling of the data centers instead of the fresh water that we seem to be running out of.
And now a comparison of the produced water acts in each state. Now, both of the acts are pretty similar in writing. Both establish governing boards. More specifically, produced water in Texas is primarily governed by the Railroad Commission for treatment and all non-discharge beneficial use, and by the Texas Commission on Environmental Quality for direct surface discharges to what is considered water in the state, which is surface water. Meanwhile, in New Mexico, produced water is primarily governed by the Oil Conservation Division of the Energy, Minerals, and Natural Resources Department with regards to all oil and gas production, and the New Mexico Water Quality Control Commission for all other uses. The two states are also similar in how their statutes address ownership, in that unless contracted for otherwise, produced water is owned by the person who takes possession of it. Meanwhile, while the statutes are similar, the states are worlds apart in actual application. New Mexico, for example, has effectually halted permitting of injection wells for the time being, and their pilot programs are focused on treatment. In April 2025, the Water Quality Control Commission adopted a draft version of a rule that would allow pilot projects using oil and gas wastewater to discharge up to 84,000 gallons per day into groundwater. In May 2025, the Water Quality Control Commission went back on this decision, saying there was not enough evidence to support discharge of the wastewater. And Mike Hightower, the Produced Water Consortium Program Director in New Mexico, says, nobody's going to do a small pilot project that takes a year and a half to get permitted when they can go to Texas and get it with no permit or a permit that takes a couple of weeks. Meanwhile, Texas pilot programs have moved on significantly to using produced water. As of early 2026, the TCEQ is reviewing at least 4 permit applications that will allow the discharge of treated produced water in the Pecos River watershed and the lower Atascosa River. At least 6 pilot projects have been permitted for the use of treated produced water in crop irrigation in West Texas. So now, where do we go from here? In Texas, with the Cactus decision, we really see 2 places where there will be a significant impact. First, in future leases, lessors and surface owners will probably be requesting compensation for their produced water. They will also probably be requesting stronger indemnities for the disposal and transportation of produced water from their tracts. With regard to existing leases, this is where it gets a little murky. The Cactus decision did not decide whether the lessee owes the lessor or surface owner royalties on any produced water. There will probably be litigation on how parties account for any profit or loss realized from disposal or transportation of produced water. And the question of whether lessees are subject to any implied covenants with respect to management or disposal of produced water is still outstanding. And finally, does transferring ownership of the surface owner's real property right to groundwater to the operator recycler constitute an unconstitutional taking?
Now on to New Mexico. New Mexico is moving forward on the produced water front by way of legislation. In the Senate, we have Senate Memorial 11. A Senate Memorial is a formal legislative document that expresses an opinion, requests an action from an agency, or honors an individual. A Senate Memorial does not pass a law. Senate Memorial 11 was introduced this year and requests that the Water Quality Control Commission promulgate rules enabling the beneficial reuse of treated produced water. As discussed, the Water Quality Control Commission has started down this path before, but in the 11th hour, they just really can't get there. So, the senator from Taos County, which is up north, pretty much as north as you can get in New Mexico, introduced this memorial. The memorial focuses on the beneficial reuse of produced water for data centers specifically. Data centers need to be cooled, so instead of using fresh water, why not develop the rules so these data centers can be using produced water? The New Mexico House is also moving on produced water. Representatives there have introduced House Bill 207. Essentially, the House is telling the Commission that it should adopt rules that establish permits allowing for treated produced water to be used in pilot projects, closed-loop geothermal projects, irrigation of industrial crops, use in roadway ice and dust control, discharge into surface waters, and more. This bill is doing so by amending the duties and powers regulated to the Water Quality Control Commission. This bill would also ask the Water Quality Control Commission to adopt these rules no later than December 31st of this year. So it looks like both chambers of the government are trying to get the Water Quality Control Commission to move forward with the beneficial reuse of produced water. On to the federal government. It looks like the federal government is also moving towards a more positive outlook on the beneficial reuse of produced water. In 2020, as part of the National Water Reuse Action Plan released by the EPA, the federal government identified oil and gas produced water as a potential source for future water sources. The purpose of this action plan is to improve the security and sustainability of the nation's water resources. So, factoring in produced water is a positive sign. And then, as recently as February of this year, BLM New Mexico released an updated policy and guidance relating to the produced waters from oil and gas production on public land, where the BLM was encouraging the support of produced water reuse practices. The BLM is wanting to work with the oil and gas industry to identify opportunities for reusing and recycling produced water, and their intent is to promote the adoption of practices that preserve and increase freshwater supplies by recycling produced water for a variety of applications. So, the hope is if you go to a BLM officer to offer an alternative produced water disposal method, they will be more likely to approve this alternative method. Okay, now for some questions. Looks like we have a question in the chat. If it's cheaper to use injection wells to dispose of the produced water, why can't we rely on that? Well, as we discussed, New Mexico has effectively halted injection wells, and Texas has slowed permitting, but they've done so both because of increased seismic activity, and we actually go into it a little bit more in the Murky Waters presentation, but we are looking for an alternative, and if we can, I know the alternative is expensive now, but with more research, maybe we can bring these costs down and why it's important to, look at these alternatives now.
Okay, I see we have another question. Someone asks, who owns produced water once it's injected into an injection well? Well, while we don't have a case directly on point on that in Texas, we anticipate that it will be treated very similarly to natural gas that is produced and then re-injected into an injection well, where the natural gas is deemed personal property and it retains that status when it is injected into the ground. We would anticipate that the same would be true of produced water.
And it looks like we have one more. Is disposal of produced water a part of post-production costs that can be charged back to the lessor? Well, it really depends on the lease. Both the Produced Water Acts both explicitly say that the lease or another binding contract is really what governs here. So really look towards the lease. Now, if you have any questions about what we talked about today, or you'd like to discuss further about where we see produced water legislation heading, please reach out. Thank you so much for attending our H2O Brother webinar over produced water in Texas and New Mexico. Have a great day.